Thank you. Thank you very much. Does this need to be closer? That's probably better. Okay. Thank you, Ted. Thank you, Abigail, for coming to speak here, and thank you to the Federalist Society, Lee in particular, and all of you for coming out. This is a pretty good turnout. I think this is the best FedSoc turnout I've gotten so far. We're going to be talking today about, maybe this is too close. We're going to be talking today about 4 cases that have been brought in 4 different federal district courts, not challenging, but related to the Patient Protection and Affordable Care Act. They haven't received much attention, but these cases could have a tremendous impact on that law. As one law professor from my alma mater put it, this is huge. Quote, this is huge. All of Obamacare hangs on the outcome. Our topic today, I hasten to clarify, though, is not whether the Patient Protection and Affordable Care Act was a good idea, or whether it's a good law, whether it's going to help people, whether it's going to hurt people. That's a topic for another day. Our topic today is whether the IRS is attempting to tax and spend vast sums of money, contrary both to congressional intent and the clear language of the PPACA. Our topic is therefore the rule of law, whether the IRS must obey the health care law that President Obama himself signed. That question arises because the Obama administration, I will argue, is attempting to tax and borrow and spend nearly $1 trillion over the next 10 years without congressional authorization. The agency is taking this rather breathtaking step under the rubric of the Patient Protection and Affordable Care Act, but contrary to both congressional intent and the clear language of that statute. If true, this would be a more egregious example of taxation without representation than the Stamp Act. Unfortunately, the facts don't permit any other conclusion. I've researched the statute and the legislative history more than probably anybody. The statute is clear. It is consistent. It is unambiguous. Though it comes as a surprise to most everyone who's examined this issue, as it came as a surprise to me, it is likewise clear that this was precisely Congress's intent. None of the available evidence supports the IRS's position. All of the evidence shows the IRS is violating both the statute and congressional intent, and nor can the government cite any legal theories that would permit the IRS to override the clear, consistent, and unambiguous language of the statute. Though the Obama administration is hotly contesting these challenges, neither it nor its defenders have offered any evidence from the statute or the legislative history that supports either their theory that Congress intended to let the IRS do what it is doing, or the government's bizarre claim that the statute is ambiguous. Before we get into the nuts and bolts of this, I need to give you a little overview of how this law works. You are probably aware that it takes full effect in January of 2014, and October 1st, people were supposed to be able to buy health insurance through online websites run by health insurance exchanges created either by the states or the federal government. There's been a little bit of complication along those lines, but that's how the law is supposed to work. One of the features of this law is that a lot of people, oh, you know what? I skipped over a slide. The plaintiffs, I wanted to say something about the cases. The plaintiffs in these 4 cases include 2 states, 15 school districts, 3 private employers, and 8 individual taxpayers of modest means. They are alleging that beginning in 2014, they will be subject to the unauthorized taxes that the IRS is trying to impose. The Justice Department is defending the IRS with President Obama's support. If just one of these challenges succeeds and the Obama administration has to implement the PPACA as Congress intended, it could have, again, a tremendous impact on that law. So, one of the features of these health insurance exchanges is that young and or healthy people will see higher premiums than they would in a market without this law's pre-existing condition provisions, or what I call community rating price controls. So a lot of people are going to experience rate shock. This cartoon shows, says rate shock of 88%. A lot of people are seeing their premiums double, so increases of 100%. Some people are seeing increases of 200%. And there have even been reports of premium increases of 400%. If that happens, if a lot of people see their premiums go up like this, the penalty for not purchasing health insurance is actually a very small fraction of the premiums that most people have to pay. So a lot of people will probably quite rationally say, well, I'm not going to sign up for health insurance. I'm going to pay the penalty and wait until I get sick to buy coverage. The government or the insurance companies can't charge me anymore than they charge anyone else when that happens. So one of the features that they built into this law to try to prevent that dynamic, which is known as adverse selection and which has caused health insurance markets to collapse, is they included a lot of subsidies in this law, a lot of subsidies to hide from people the full cost of the premiums that they would be paying. These subsidies, we call them tax credits, but they're really tax credits in name only. They're government subsidies. You pay the same amount of money to the IRS. They just take some of that and send it directly to an insurance company. We're here because Congress asked states to establish the health insurance exchanges through which these tax credits would flow, and conditioned the availability of those tax credits on states taking that step, establishing those exchanges. But what happened was 34 states have refused to establish an exchange. A huge electoral backlash in 2010, and that continued in 2012, led to a lot of Republicans being elected in these state legislatures. And although it's not exclusively Republicans that have been dragging their heels on this and refusing to establish health insurance exchanges, that has been a big factor. In fact, in at least one state, it was a referendum that prevented, it's Missouri, by referendum, the voters said, no, we're not going to establish an exchange ourselves. So we've got 34 states now who are refusing to establish a health insurance exchange. If those subsidies are not available in those states, that presents a very big problem for the law. You've heard about all the glitches that have been happening with the websites ever since October 1st. That's actually a pretty big problem for the law, because it could lead to that adverse selection dynamic I was talking about before. But this one, those subsidies not being available in 34 states, two-thirds of the U.S., two-thirds of the U.S. population, is an even bigger problem. And when we're talking about these subsidies, we're talking about $1 trillion over the next 10 years. And two-thirds of the states are by law blocking those subsidies. So why would Congress do this? Why would Congress give states the ability to block those subsidies, especially since they're such a crucial part of the law? Well, Bill Clinton gives us the answer, as he so often does. Former President Clinton gives us the answer. Here, in this video, I'm not going to play it for you, but in this video, he's speaking to a group of congressional Democrats. They had a retreat. All the Democrats in Congress went and had a retreat. Bill Clinton spoke to them. It was in 2011, I think it was. No, I think it might have been earlier this year. Yeah, February. And what he said to them was, quote, "It was the best bill you could have passed in the Congress under the circumstances, given the filibuster problem in the Senate," end quote. He's talking about the health care law. What do you mean by that? Well, in 2009, 2010, at least for a couple days in 2010, Democrats had a 60-vote majority in the Senate, which you need if you are going to overcome the united opposition of all 40 Republicans, because they could, if Republicans had just one more vote, if they got just one Democrat to vote with them, they could block any health care bill that the majority Democrats wanted to push through the Senate. So if they wanted to get a law through a health care law through the Senate, they needed every single Democratic vote, which means they could not get in their health care law a lot of things that a lot of Democrats wanted. You may have heard about a public option, a government plan, health plan that's supposed to compete with private health plans. There was one in the House bill. They couldn't get one in the Senate bill because there are a lot of Senate Democrats who refused to go along with that, and without their votes, there would be no health care bill. Another objection that Senate Democrats had to a feature in the House bill was, in the House bill, the health insurance exchanges would be run by the federal government. In fact, there would be one exchange. And a number of moderate Democrats, Ben Nelson from Nebraska, Joe Lieberman, who was at the time an independent but caucusing with the Democrats, said, we can't go along with federally run exchange. We need the states to be running the exchanges. Well, that created a problem. Well, I should say, so the Senate bill, instead of having the federal government run the exchanges, had states run the exchanges and said the federal government will run the exchanges, the states refuse. That bill, as you know, passed the Senate. Then, as soon as it did, Democrats lost their filibuster-proof majority when Scott Brown was elected from the great state of Massachusetts, meaning that Democrats would never again get a health care bill through the Senate, because Scott Brown had vowed to vote with the Republicans to block any bill getting through the Senate again. The Democrats' only choice then was for the House to pass the Senate bill. But Senator Nelson, Senator Lieberman, a number of other moderate Democrats, they created a problem. Oh, don't look at that yet. I was going to ask you a question. They created a problem for the authors of this law. Does anyone know what that problem was? If they said that states have to run the exchanges, what's the problem? Is there a problem with the federal government telling states you have to implement this federal program? Yes. Right, you can't compel the states to act. The federal government can't compel the states to act. It's called commandeering. We relearned in NFIB versus Sebelius that the federal government cannot commandeer the states, but it can create incentives for states to implement a federal program. And so that's what the authors of the Senate health care bill did. This is a law professor named Timothy Jost, Washington Lee University, very influential in the drafting and implementation of the Patient Protection and Affordable Care Act. He testified for Congress. He was even invited to the signing ceremony at the White House. In January 2009, before anyone put any of these bills down on paper in legislative language, he said, you know what? If we want the states to run it, here's one thing you could do to get around that commandeering problem we were talking about. He said Congress could invite state participation in a federal program by offering tax subsidies for insurance only in states that complied with federal requirements. Early 2009. Later in 2009, as the Senate was writing its bill, I have a much longer quote from him where he not only talks about how they could do this and how it would work, but how Congress has done this before with the tax code with regard to health savings accounts. So in an early version of the Senate bill, its lead author, Senate Finance Committee Chairman Max Baucus, included a workaround to the commandeering problem, the very workaround that Timothy Jost proposed. So when you look at the bill, that Baucus bill, that Jost-Baucus language survived. It went from the Senate Finance Committee to the Senate floor, to the House floor, to the President's desk. You had bicameralism, presentment, boom, it's the law. And if you look at that language, it's very clear, it's very consistent, it is unambiguous. Every single mention of an exchange in the tax credit eligibility rules in this law is a reference to an exchange, quote, I've got a laser pointer here, awesome, established by the state under Section 1311. These are all the different places where it's mentioned. I'm going to start with coverage month. You can only get a tax credit during a coverage month. What is a coverage month? Well, it's got a long definition, but it only occurs when that taxpayer is enrolled in an exchange enrolled in a health plan through an exchange established by the state under Section 1311 of the Patient Protection and Affordable Care Act. Again, if states decline to establish an exchange, the law directs HHS to establish one, but it doesn't authorize tax credits. There's nothing authorizing tax credits through a federal exchange. This is no different from what Congress does under the Medicaid program. Anyone familiar with the Medicaid program? Created by Congress, run by 50 states. Congress says to states, we can't commandeer you, but hey, we'll give you some money, we'll give your constituents money, we'll give your residents these subsidies if you implement this federal program. It's the same thing that they're doing here. And as it happens, and that's also what they did elsewhere in this same bill with the Medicaid expansion provisions. And if you look at the other leading Senate Democratic health care bill, they did the same thing there. They said to states, implement the employer mandate portion of this bill and your residents will get subsidies. Don't implement it, and they won't. And it's not just the coverage month definition. If you look at the premium assistance credit amount definition, it refers to both coverage months and premium assistance amounts. Here, to calculate the premium assistance amount, you have to look at the premiums for a plan that was enrolled in through an exchange established by the state under Section 1311. The applicable second lowest cost silver plan is another part of calculating the tax credit amounts. You cannot calculate the the applicable second lowest cost silver plan is offered through the same exchange through which the qualified health plan taken into account in paragraph 2A were offered. What is 2A? Again, we're talking about an exchange established by the state. So, and then we've got one more, the adjusted monthly premium, again referring to the exchanges or the premiums under paragraph 2A, which can only be calculated, which are premiums offered through an exchange established by the state. So you can only have a coverage month if the state established an exchange. You can only calculate the premiums if the state established an exchange. The law is very clear, it's very consistent, it's very tightly worded. Remember how slapdash this bill was supposed to be with all the errors in it? There's not a single error here. There's not a single ambiguity. There's nothing opening the door to tax credits in an exchange established by the federal government under Section 1321. It's Section 1321 that tells the federal government if the state does not establish an exchange, the secretary has to establish one. And in regulations, I have that excerpt later from the statute later on, but in regulations, the Obama administration itself seemed to understand that there's a difference between the two. It said that a federal exchange is one established and operated within a state, not by a state, within a state by the secretary, not a state, under Section 1321, not Section 1311, so there's a difference. It's not just Michael Cannon of the Cato Institute who says this language is clear. This is a Congressional Research Service. If you want to read the quote later, I'll do that for you. They say that the language is clear. Professor Jost, in an unguarded moment when we first raised this issue, he was on, he said that the language is clear. And let's see, HHS, I'll skip over that part, but basically what it means is that, the same language established by a state under Section 1311 is used elsewhere in the bill to motivate states to establish an exchange. Congress said to states, you have to keep spending this money on Medicaid, you have to keep your eligibility levels where they are until you establish an exchange established by the state under Section 1311. This is from HHS, a letter from HHS to states showing that they, back in 2011, before they realized that states weren't going to be establishing exchanges, they knew what that language meant. And finally, the government admitted, implicitly, but admitted that that language is clear and that the plaintiffs in these lawsuits I was mentioning are reading it correctly when they said that the plaintiffs err by reading those passages in isolation. Not that there's anything wrong with their interpretation of those passages as they are, just that they aren't looking at the rest of the statute, and we can get into that later. Finally, to really beat this dead horse, but this is our smoking gun. Anyone know who this is? Come on, you guys got to watch C-SPAN. Senator Max Baucus, Democrat, Montana, chairman of the Senate Finance Committee, lead author of the Patient Protection and Affordable Care Act. I already mentioned him. It was him, or it was he, who took Timothy Joe's suggestion, put it into statute, put it into legislative language, introduced it in his Finance Committee, got it approved there, and then helped it get all the way to the president's desk. Max Baucus, September 23rd, 2009, in an open committee markup, was challenged by Republican Senator John Ensign from Nevada. How do we, the Senate's tax writing committee, even have jurisdiction to be telling states to establish exchanges? What did Max Baucus say? He said, there are conditions to participating in an exchange. An exchange is essentially tax credits, and tax credits are in the jurisdiction of this committee. Senate Finance Committee does this sort of thing all the time. They have a certain jurisdiction. They want to legislate outside that jurisdiction. They create a tax benefit, and then they condition some behavior outside their jurisdiction on people receiving that benefit or on states receiving that benefit. And what he said in response to Senator Ensign was, we are creating tax credits, and we are placing conditions on them, and that's how we can get states to establish exchanges, by conditioning the tax credits on state cooperation. Horse's mouth, smoking gun. You've got statute, you've got legislative history. Conversation should be over. And we even have one more reason why they had to put this language in there. In addition to the commandeering problem, they had to put they had to make the tax credits conditional so that the Senate Finance Committee could have jurisdiction to tell states to do this. Now, why? Interestingly, when you look at the legislative history, and I have, there's very little in the legislative history, precious little, about what Congress intended to happen if states don't establish exchanges. In fact, this is the only comment on point from any member of Congress that we were able to find. in the legislative history, in the congressional record, and another legislative history. The reason is, as the New York Times reported, everyone thought states were going to establish exchanges. No one thought this was going to be an issue. But President Obama, other lawmakers, all assumed this would be the case. In fact, they didn't even put any funding in the law for the federal government to create exchanges because they thought it was such a far-fetched possibility. But turns out, 34 states refused. Around the time that it became clear that states were going to refuse to establish exchanges, enter the IRS, our nonpartisan IRS. Is that me? Because I think all your mics are hot. It just does that sometimes. Okay. As it became clear that states were not going to be establishing exchanges, the IRS issued a proposed rule. It said that we're going to be offering tax credits through exchanges established under Section 1311 or 1321. These 6 characters are found nowhere in the statute. There's absolutely no support for these 6 characters in the statute. People brought this up with the IRS. They issued comments. The IRS said, meh. They went ahead and finalized their rule in May of 2012, effectively with a stroke of a pen, repealing those Joe Baucus provisions, restricting tax credits to states that establish exchanges. Now, in the process, the agency violated what it knows is a fundamental canon of statutory interpretation. When it came to another provision of the law, they said to accept the commenter's argument would require ignoring the words and their dependents in their entirety, yet they completely ignored repeated uses of the phrase established by the state under Section 1311. And this isn't chump change that we're talking about. I mentioned before that this is $1 trillion, nearly $1 trillion. That's because this is from the CBO. This is the amount of money that the IRS is going to send to insurance companies over 10 years if all states establish exchanges, if there are these tax credits in all states. It's over $1 trillion. And if you look at the share that would flow through those 34 states where they're trying to issue those subsidies without statutory authorization, it comes to over $700 billion. So with those 6 characters, OR 1321, the IRS is proposing to tax, borrow, and spend without congressional authorization, $700 billion. Okay. Now, can they get away with it? Well, how much time have I taken so far? Oh, well, that means, I'll assume that means 5 minutes, which it doesn't mean. That I've taken 5 minutes, which isn't one of the, okay. All right, I'll try to make the rest of this brief. The plaintiffs in this case, both 2 district courts have found that employers and individuals have standing to challenge this IRS rule. It's under the Administrative Procedure Act because these illegal subsidies will trigger illegal penalties against employers and individuals. So skipping to these, to whether the IRS is going to be able to get away with it. The IRS will have to avail itself of basically one of these 3 doctrines that allow administrative agencies to ignore the clear language of a statute, or to ignore the language of a statute. One is if there's a scrivener's error, that's usually an error of transcription or typographical error. Supported to this law, like Professor Joseph said, no, that doesn't fit here. They're not going to find it's a typographic error. Another is the absurd results doctrine. If a literal reading of a statute would lead to an absurd result, courts say that agencies can ignore that or work around that, but the language has to be implausible. That doesn't work here because we've seen that the language is not only plausible, but that's clearly what Congress intended. And they have to find overwhelming evidence that the language is implausible when, in fact, there's none. The evidence is overwhelming in the other direction. Finally, Chevron deference. Who's taken admin law so far? No hands. Okay. Chevron deference, courts will defer to administrative agencies if a statute is ambiguous or there's a gap to be filled, and if the agency's resolution of that ambiguity or filling of that gap is neither arbitrary or capricious, nor contrary to law, nor a major question. And the IRS's tax credit rule, their attempt to issue those subsidies in all these states, is arbitrary and capricious and clearly contrary to law, and a major question involving the expenditure of $700 billion without congressional authorization. So there are a lot of defenses that have been offered of the IRS rule. They've really gone on a fishing expedition to try to find something that will allow them to override the clear and unambiguously expressed will of Congress. They haven't found anything. Every time they say, oh, we've got a bite, they reel it in. It's not a fish, it's like a shoe. And then they toss that back in. And then they, oh, we've got another bite here, and they reel it in, and it turns out it's a car tire. I've got a partial list of what some of these theories are, and I hope that we could talk about them. But I am clearly over time, and I want to give Abigail her due. So, Professor, please. And Q&A is usually the best antidote for glazed over looks. Before we do Q&A, though, I want to recognize and thank one more person for coming here. Leslie Crulley is the secretary of the University of Pennsylvania. So if you guys need a parking space or a grade fixed or something like that, she's the person to talk to. She's also my mother-in-law's sister. So yes, she is here to monitor somebody, but it's not you. So, any questions? Yes?
When Professor Moncrief mentioned that the subsidies under the IRS rule were directly to the citizens, you vociferously shook your head no.
Oh, you noticed that. Oh, you're sitting right next to me. Well, that was, don't worry about my feelings. This stuff is more important than my feelings are, just as I won't worry about yours when I give this answer. That really terrible argument doesn't really make any sense because the money doesn't go to the citizens, it goes to insurance companies. I explained that earlier. The money goes to citizens under Medicaid just as much as it goes to citizens under the tax credit provisions of the exchange provisions of this law. The money goes to the states for the benefit of the citizens who then receive subsidized medical care. The money goes to the insurance companies and then to the taxpayers who receive subsidized medical care. I mean, there's no difference there. Now the argument that you're trying to make is that the money goes to the state rather than the individual. You know, I think I just made that point. So yeah, go ahead, please.
But the difference between a state and an insurance company, that being, and the difference between the state and an individual, there's no difference between those two differences, if that makes sense. The insurance companies are citizens. Insurance companies are private entities. The state is not a private entity. So when we talk about fiscal federalism, we talk about the spending clause and when the federal government can give money to the states, under what conditions can the federal government attach to the money that it gives to the states. All of those things are questions that matter for constitutional law under South Dakota against Dole, under the anti-commandeering doctrine, under now Infant against Bilius. Those are not questions that come up at all when the federal government gives money to private businesses, private individuals, private entities of any kind. There's no such thing as anti-commandeering doctrine for individuals or for private businesses or anything like that. So when we talk about the federal government giving money to individual insurance companies, which then pass that money along to individual citizens, that pass-through doesn't matter. But when we talk about the federal government giving money to states, which then passes that money on to individual citizens, that pass-through matters a lot.
But the federal government cannot commandeer states and can only commandeer citizens under certain conditions, correct? Right, okay. But because it cannot commandeer states, it has to create incentives, correct? And there are limitations on the incentives. We learned about one of them in NFAB versus Sebelius. It can't be coercive wherever that magical line is drawn. But is there anything contrary to law, anything unconstitutional, anything unlawful about offering the credits that it did, offering the tax credits that it did? And keep in mind that Professor Jost proposed the idea that Senator Baucus admitted this is what they were doing for both jurisdictional and constitutional reasons, and that this is not the first time that they have enacted tax provisions that would vary from state to state. In fact, Professor Jost talked about health savings accounts. Congress created tax benefits for deposits to health savings accounts for certain people. To get these tax benefits, you had to open a qualified high deductible health plan, and only some states allowed those sorts of high deductible health plans. So you had a situation where individual citizens would be getting a tax benefit or not getting a tax benefit based on state law.
Yeah, I think that there might be a problem if Congress said, I think there would be a constitutional problem if Congress said, we're going to give $100 to all the citizens of the state of Massachusetts, but nobody else, right? So if Congress came out and just said, we're just going to give,
Congress does that all the time.
Cash, but not based on just state citizenship, because there's this right of travel and the welfare cases that say that you can't discriminate based on state of citizenship or length of citizenship in any particular case. And
so they come up with very cleverly worded ways to confine it just to Louisiana.
Well, but if they do it based on Louisiana having a choice of whether or not it can get, so this was sort of a side note, so I think that there is a problem of discrimination on the basis of state citizenship. I don't think there's a problem necessarily if the state has the power to then fix the problem for its citizens, right? So if the state can fix the problem
So is your point that Congress could not possibly have intended to do that?
My point is that Congress certainly did not intend to do that here. I'm not sure.
Even though people had proposed the very idea. I mean,
I think what you mean, one quote from Baucus. That's all you.
and Timothy Jost.
But Tim Jost is not in Congress, and Tim Jost is
And it's not all that we've got from legislators. And it's and he was very influential in the process, and you know that he was very influential in the process. And it's not the only. There's also a letter. Again, there's scant legislative history here. There's also a letter from 11 Texas Democrats to Pelosi, to the Speaker of the House, Majority Leader, and the President, saying we don't want the Senate's approach to exchanges because when states are left to implement these things, they can block them, they can refuse, and then their citizens will not receive any benefit. Quote, any benefit. And so that says that these 11 Texas Democrats who are in a state that they thought was likely not to establish an exchange were concerned that their residents would not receive any benefit. And the reason they wouldn't is because they drew an analogy to the state children's health insurance program. Part of that, the state of Texas decided not to implement. Works just like Medicaid. You don't implement it, you don't get the federal dollars. So we've got people proposing it beforehand. We've got the guy who wrote the bill. We've got the clear language of the statute. We've got CRS saying it. We've got Tim Jost saying it. We've got the government admitting it. How is it so hard to believe that this is what Congress did?
We've also got 100% of the CBO estimates, including the most recent one saying that the subsidies were going to go everywhere.
But that's not on point. But that's not on point. They could have, they like everyone else, assumed that every state was going to establish an exchange. And CBO acknowledged they did not. CBO acknowledged they did not do a legal analysis of this question of whether tax credits would be available in federal exchanges. They just assumed that
because everybody, 100% of everybody, assumed that all of the states were going to set up their exchanges,
okay.
which just answers all of these questions, right?
I think it answers a lot of them. Anyway, we're having a lot of. I don't know if this is interesting for all of you.
We only have one microphone, so there's a little bit of an unfair advantage.
Yeah, I know. I sound a lot louder.
Wants to
I can move this farther down.
Well, I want to step in just
and moderate.
As we want to take other questions. I'm sure there are other questions, so we can keep debating this one. But yes, Aaron. And speak loudly, please.
I understand when the Senate amended the bill, it gave the states choice to implement the exchanges.
When which senator wrote the bill?
When the Senate amended the bill, originally it was going to be a federal exchange.
Well, actually, it wasn't the bill yet when he made that decision. It was still just sort of a white paper, but a lot of people suggested the exchanges should be state-run, and so when Senate Finance Committee Chairman Max Baucus introduced his first draft of that bill, it did include state-run exchanges. It told the states, you have to run exchanges. Shall.
But I'm saying that what the Senate did was, instead of having the federal government have one large exchange, it delegated it to the states.
Correct.
And isn't it true that in order to sort of force or convince the states to create exchanges, they had to make consequences for them not to do it? So isn't that the reason why they wouldn't have put in 1321?
Well, they didn't have to have consequences for the states not to do it. There's no need for there to be a stick. There's no stick in Medicaid. Arizona didn't have a Medicaid program until 21 years after the Medicaid bill was first passed, and nothing bad happened to Arizona. And nothing bad happened to a lot of states dragged their heels and implemented.
Then there's no stick here.
Obamacare. Can you say more? Why would a state want to do it instead of punching back?
Well, and that's the carrot is the huge amount of money that you get to set up your exchange. And the federal government was financing 100% of the exchanges. The carrot is we pay for 100% of this policy to be implemented, and we think that you're going to think it's a good policy, which is the same thing as passing Medicaid.
Can't you say the carrot is also that they were trying to make them set up the exchange, otherwise they would give them the subsidies? That's what this 1321
And to,
Let me just, I think the huge carrot for states in setting up their own exchange, and why lots of the so-called red states have set up exchanges, is tremendous policy discretion. HHS is allowing huge flexibility so that you can tell this is profoundly different than Massachusetts.
I would dispute that. There's no policy flexibility there. That's not a carrot.
We had the head of Utah's exchange here on campus in August.
And they declined to create one. They're not doing their own, they're doing their own shop, they're not doing their own individual. If there's such great flexibility, I mean, maybe Utah would have done it, but they didn't. So,
Shop exchange looks very different.
and they already had one. That's why they wanted to keep running it. But there's a canon of statutory interpretation that says, you know, that the courts and administrative agencies are to interpret statutes so as not to create surplusage. And the only way to interpret the statute without surplusage is to give meaning to the words that Professor Moncrief says are meaningless, established by the state under Section 1311. Whereas her method or the IRS's method of interpreting the statute creates surplusage all over the place, says that those words are meaningless, and relies on the absurdity that the federal government can establish an exchange established by a state. Yes, sir. Oh, sorry.
Let's take one question.
I have a question for Professor Moncrief. And I guess maybe because I didn't but it seems like there are two components. One is a sort of standing. This isn't really a sort of constitutional jurisprudence, but constitutional jurisprudence would suggest that. And then there's this sort of statutory interpretation, be kind of crazy to interpret the statute this way. I guess I took your argument to be sort of combining the two, at least the former informing the latter. And I guess I wanted to know, what do you think it would be dispositive for the case if the court does grant standing? That is to say, like, if they say there is a harm.
No, so let me clarify what I was saying. So the plaintiffs here want to say that the overall statutory scheme makes perfect sense without subsidies on the federally run exchange, because the absence of subsidies would then leave the state for the states to set up their own exchanges. But then later in their complaint, they say, if you don't give subsidies in a state that doesn't have its own exchange, then the mandates don't apply in that state. And all of the other provisions of Obamacare that are meant to keep the insurance market whole and running go away. Which makes the idea that there might not be subsidies in any particular state seem completely crazy. Because there's just no way Congress could have meant to eliminate the mandates for this many people in 36 states. It doesn't make sense that Congress would do it that way. The mandate was the linchpin of the entire statutory scheme. It was what was supposed to keep the insurance market going. It was also a major political concession to the insurance market, right? And so my point was only the reason that they did this, that they undercut their whole argument by saying that getting rid of the subsidies gets rid of the mandates, was that they hadn't established standing. So in the necessity of establishing standing, they made their argument bogus.
I'm not going to argue that this law is not crazy. It certainly is crazy, but not for that reason. Professor Moncrief is claiming that Congress couldn't have intended to do this because it would have wrecked insurance markets, except Congress did the exact same thing two other places in the bill, the exact same thing. Created the community rating price controls that I mentioned earlier, which lead to adverse selection, which destroys insurance markets, and imposed them on the market for child-only health insurance 6 months after the law took effect. Without a mandate, without the subsidies that she says they would not have missed or forgotten to include. And what happened? In 18 states, the child-only market collapsed immediately. In another 17 states, the insurers fled the market, so it's in a slow adverse selection death spiral in those states. And the other example was the Class Act. Anyone hear of that? The Class Act was a new long-term care entitlement program. You get insurance for nursing home and other long-term care services from the government, but the government has to charge everyone the same premium, and there's no subsidies and no mandate. The reason you never heard of the Class Act is because they already repealed it because they realized it wouldn't work. So two because of adverse selection. So two examples that show that yes, Congress would do that because they did it elsewhere in the same bill.
I would say that's just because, again, Congress isn't totally incredibly stupid. And,
Consensus, finally.
but those were much smaller errors. If you think about a child-only market collapsing, it will come back under the mandate and another provision is going to go back and rebuild the insurance market as a whole. When you're talking about destroying the whole insurance market in a particular state by getting rid of the subsidies and the mandates, but not by getting rid of community rating and adverse selection, or community rating and pre-existing condition guarantee issue requirements, then you're talking about a much, much more severe problem. And they do that. They do that for sure.
Well, I think you both agreed that everybody expected all the states to set up their own exchanges under which the subsidies would be available. And so if that was the expectation, isn't that an implicit acknowledgement that the intent of the legislation was to facilitate subsidies in every state?
That's my
Yeah, of course it was.
So isn't it?
But that's not the same thing as saying that the intent was to offer tax credits through federal exchange. Just as it is, even though Congress wanted a Medicaid program in every state, that doesn't mean they were going to send checks to states that didn't implement a Medicaid program. In fact, that just shows the government doesn't even believe its own arguments here. They've said that Congress would not have intended this. Congress would not have intended to withhold funds from states that didn't cooperate. Well, if that's the case, are they going to start sending checks to the 25 states that have refused to implement the PPACA's Medicaid expansion? No, they're not, because they know that what they just said over here is not true.
I think the issue that I'm having is that a subsidy, the carrot and stick approach, seems more to me like a tool to facilitate the true intent rather than the intent itself.
Well, this gets back to another point that Professor Moncrief raised, which is that it seems contrary to the purpose of the statute, or contrary to Congress's intent. But statutes don't have just one purpose. And if you want proof, look at the title of this statute, Patient Protection and Affordable Care Act. There are two purposes there that are often at odds with each other. And there are other purposes in the statute. One of them was to get states, well, to have the exchanges run by states because political constraints and constitutional constraints said that's the only way you're going to get a bill through Congress. So that's what they did. In order to pursue that purpose, Congress created this carrot for states. So was it Congress's intent? Absolutely. And it served the purpose of getting a bill, because if they hadn't done this, they wouldn't have gotten a bill through Congress if they didn't find some way around the commandeering problem.
Let me just say this really quickly. I think even if I were to admit, which I am not doing, that this was right, that there's a specific intent not to provide subsidies on the exchanges, and that the members of Congress, in all of their profound idiocy, actually thought that that was the right way to run the Obamacare scheme when they wrote the statute. That actually does not mean that the courts are going to hold that the IRS's interpretation is unsustainable under Chevron deference. So we have this long history of
we're going to, thank you, we're going to deviate from our original intent to end at 1:15 to allow 1 minute for one last question. You've had your hand up for a while.
I was just going to ask, and this may be basic, so we're saying